You are listening to the Advocates of Aging podcast. This podcast is produced by the ABA Commission on Law and Aging. Listen to hear interviews and stories on topics related to law and aging, including best practice tips for professionals and career advice. Age is not just a number, it is an opportunity for growth and fulfillment. These episodes will explore the hurdles people face when aging, as well as opportunities for improving advocacy and strengthening the legal rights of others.
Hi, I'm Erica Costello, and along with Jessica Brock, we're with the American Bar Association's Commission on Law and Aging. You are listening to our Advocates of Aging podcast. In celebration of Healthcare Decisions Day, we are dedicating this episode to a conversation about the Uniform Healthcare Decisions Act and why trauma-informed planning is a critical consideration for practitioners. Today, our guests are Nina Kohn and Deirdre Locke. Nina Kohn is the David M. Levy Professor of Law at Syracuse University College of Law, a distinguished scholar in elder law with Yale Law School's Solomon Center for Health Law and Policy, and a member of the American Law Institute. Nina is a leading expert in elder law, advanced planning, and medical consent, and the civil rights of older adults and those with diminished cognitive capacity. She served as the reporter for the Uniform Healthcare Decisions Act and the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. Deirdre Locke is the Director and Managing Attorney at the Weinberg Center for Elder Justice, where she leads a multidisciplinary team in the development of the National Elder Abuse Shelter Model, with services that include direct legal, clinical, and medical support for older adults who have experienced harm. An adjunct professor at Brooklyn Law School for over 10 years, she directs the law school's Help Clinic. Deirdre is a certified trauma professional, certified dementia practitioner, elder and adult family mediator. A complete copy of their bios will be provided in the notes on our website. Thank you so much for taking the time to be with us and to share your work in this field of law and aging. As we mentioned at the top of this episode, today's conversation is about healthcare decision-making, and you both have such great experience and insight to offer on this topic. To start with, would each of you share what you do now and what prompted you to enter this field of law and aging? Nina, we'll go ahead and start with you.
Thanks. Happy to be here. Well, as you noted, I'm a law professor and I teach primarily in the fields of elder law, trust and estates, and tort law. And my scholarship looks at how the law shapes and responds to older age. And I'm particularly interested in the civil rights of older adults and individuals with cognitive disability or perceived cognitive disability. In terms of my interest, I guess I would trace my interest in law and aging to the fact, like many of us, I grew up interacting with older adults and enjoying interacting with older adults. But I think my interest also reflects the fact that when I decided that I wanted to work at the intersection of law and policy, I discovered there was a real need for more people working in law and aging. And frankly, I like to use my time productively.
Thank you so much for sharing that. In your bio, we talked a little bit about your participation with the Uniform Law Commission. Tell us a little bit more about your participation with that group responsible creating the Uniform Healthcare Decisions Act. What exactly is the Uniform Healthcare Decisions Act?
Sure. So I served as a reporter for the Uniform Act, which is basically the primary drafter. It's my job to help integrate all the ideas and work through draft after draft until we get it just right. And the Uniform Healthcare Decisions Act is model legislation, and it's model legislation that's designed to empower people to make choices about their future healthcare. And it does this by enabling individuals to create advanced directives that name someone to make decisions for them if they can't do that for themselves, and also to provide instructions or guidance about what it is they want or they don't want for themselves. And it also allows certain family members and friends to make healthcare decisions for people who have not appointed an agent. And it establishes certain duties and powers for healthcare agents and professionals, and it shields them from some liability if they act reasonably and in good faith.
Deirdre, would you share what you do now and what prompted you to enter the field of law and aging?
I am the director and managing attorney, as was mentioned in the bio, for the Weinberg Center for Elder Justice at the Hebrew Home at Riverdale. We're celebrating our 20th anniversary this year, so a really exciting time for us. A great moment to reflect on what it is that we do, our mission, and what we're trying to accomplish. In short, we are a model of an elder justice shelter where we receive referrals for cases of elder abuse in the community and work as a multidisciplinary team to assess what kind of services may be needed. It could be most supportive, guided by the older adult's wishes. And if the situation calls for it and the older adult wants to leave their home and go somewhere safe, we are housed within a skilled nursing facility and are able to provide medical support, dietary support, a bed, 3 meals a day, rehab, art therapy, all of those kinds of things, in addition to the services that our Weinberg Center multidisciplinary team can provide, which includes legal assistance, clinical counseling, case management, assistance with discharge back home in a safe way. And we also do a lot of training on elder abuse, a lot of outreach on topics that seem really relevant at the time. So right now we're actually embarking on a big scam prevention campaign, since there's been such an uptick of AI and all of the other scams that naturally come along with it being healthcare decision day. We are also in tax season. So for instance, getting those IRS scams and trying to alert everybody as to what to look out for is something that we pride ourselves in doing.
So why did the Uniform Law Commission think it important to create a uniform law on healthcare decisions?
Sure. So the Uniform Law is a model act, and what that means is that it's only law if a state chooses to adopt it as its law, as Utah did last week. And it's important to create this kind of model legislation for states because when we look at state laws in this area, many are outdated or they're incomplete. So, for example, they may leave some really important questions unanswered. For example, they might not say how you determine if somebody lacks capacity, right? They'll say, look, an agent can make decisions for a person who lacks capacity, but then not provide guidance on what level of capacity is needed or how it's determined. Also, many statutes in this area create some really unnecessary barriers to people executing advanced directives. And that's a real problem because if you don't have an advanced directive, it's less likely your wishes for yourself will be respected. And if you don't have an advanced directive, it can also make it a lot harder for your family and friends to make what are often really difficult and weighty decisions about care. So by creating the Uniform Act, what the Uniform Law Commission did was create a way for states to readily improve their laws, to make things better for patients and to make things better for healthcare providers. So what's really interesting about the Uniform Law Commission is it has this really unique ability to convene experts and create a deliberative process to draft really good legislation. So revising this particular Uniform Act was a 3-year process. We brought together an incredibly rich and diverse team of experts from around the country, representing a really broad group of stakeholders, to try to figure out how we could craft the best possible law that would meet the needs of patients and healthcare providers. And in doing that, we were able to draw on a lot of what's been learned since states originally enacted legislation in this area. Things as simple as learning that amid the COVID-19 pandemic, a lot of people had trouble creating an advance directive because they were distant from other people. And so we saw it was really important to allow remote witnessing of a power of attorney for healthcare, for example. Well, we can incorporate that into the new act. So it's really a chance to make best practice legislation available to the states and easy for them to enact.
Sounds like a very, very thoughtful process. Are there unique parts of the Uniform Act you would highlight to states considering adoption or practitioners?
Yeah, sure. There's a lot of things I'd like to highlight. Let me highlight 3 of them, and happy to discuss further. One highlight is that the Act makes it easier to determine when a surrogate may make healthcare decisions for a patient. And it does that in part by creating a clear standard for determining capacity and a process for what happens if a patient objects to a determination of incapacity and says, for example, no, look, I can do this myself. I can make my own decisions. Most states actually don't address that possibility, and that's a real big gap in the law. A second highlight of the Act that I'd point out is that it creates a clear list of powers and duties for surrogates. And that's important because as a surrogate, it's not an easy role, right? You're making hard decisions, potentially life and death decisions, and clear standards help you as the surrogate do that in a way that also provides you some protection, even if only emotional, from others who might later question those choices. And then in laying out some of the powers and duties, the Act also creates a couple duties and powers that aren't normally there. So one thing that's really interesting in the Act, for example, is that it enables a healthcare surrogate to apply for health insurance for a patient who doesn't have any other person authorized to do that. And that simple little provision may be a way to avoid guardianship for a lot of people and avoid the unnecessary civil rights implications, the unnecessary expense, the unnecessary bother. Do I have time to highlight just one more?
You do, yep.
Okay, so one more thing I would highlight in the Act is that it authorizes advance directives exclusively for mental health care. Now, a number of states have authorized this type of directive. It's often called a psychiatric advance directive. In the Act, we call it a mental health advance directive. What these do is they allow individuals to provide really specific instructions about their preferences for mental health care or appoint an agent for just that type of decision. And that's really helpful for people, especially with a history of acute mental illness. And one thing we add in there as an option for people, and again, only an option, is that people can elect to limit their ability to revoke their advance directive when they're experiencing an acute mental health event. And they get to say what that is.
Thank you for sharing that additional highlight, a very, very important part of the Uniform Act. So Deirdre, you're in New York at the Weinberg Center. How is advanced directive planning with clients who have experienced elder abuse, including clients who have been abused by a fiduciary, unique?
I think it is in the word trauma in many ways. And I think the way trauma can be exhibited differs a little bit on the situation. So, first, if somebody has been harmed, there's trauma often entailed in that harm. So, there's the initial reason of elder abuse that would bring somebody to our attention. And I should say that our interest here and my interest here really stemmed from our clients showing up in a certain way, or our clients asking for particular things, or responding to services that we were trying to provide that would offer support. So much of this, what I can talk about, is really based on experience with direct services and clients. And so naturally, when there has been a traumatic event that has happened, such that the older adult feels it's not safe at home, when they come to us, there's some trauma that happens. The harm itself can be very traumatic. So understanding what that can look like and how that can present, for instance, having a client who, had been locked in her room for, in a back room in her apartment. She did not do well when it came time to having a closed door meeting. She needed the door to be open, and recognizing that the harm that had happened to her in the community, unknowingly, we may be entering into a world in which she's triggered, or he is triggered, or they are triggered by many things. So walking into it with an awareness of what events really occurred and what their triggers might be. That's first. I would then add that it is also triggering if there has been abuse by the fiduciary who had been appointed. So whether that comes in the form of somebody who has appointed themselves and taken advantage of an older adult in some way unbeknownst to the older adult, whether it's they did not know maybe what they were signing or they were being lied to, any violation from a person you trust can be part of elder abuse, and also stand in the way of an older adult then feeling like they can trust documents and information that they're being provided, since they've already been harmed by somebody who was not supposed to do that to them. Many of the elder abuse cases that we see involve family members, and that often is a tie-in to the advanced directives that we're working with our clients to execute. That all being said, unfortunately, many times we have older adults who have been isolated as a result of the elder abuse, as a mechanism of the power and control. They have been isolated, and therefore family members, friends, and others that one might naturally appoint as their decision makers or as their surrogate decision makers don't exist in their lives anymore. And oftentimes that one person who's caused the harm and has elicited this relationship of power and control, and also isolating the older adult, is the only person that has been central to the older adult's life while the elder abuse might have been taking place. And once that relationship is discovered, or the older adult wants to do something about it, the older adult may be left with no one else to appoint to be a surrogate. And that in and of itself, can feel very traumatic and make someone feel very lonely and isolated, and frankly make them feel like they don't have anybody. So for somebody who's experienced elder abuse, there are certainly more levels of consideration that need to be taken into account, and the way that those traumas might have affected them in these various ways.
Thanks for talking about that, Deirdre, because I think a lot of practitioners work with clients in this capacity and can probably relate to these types of experiences. How does this type of client experience inform your planning process when you're working with client in these situations?
Well, it's funny that we were just talking about this model rule, but I think first and foremost, it's really important to establish that you have to, as an attorney, need to assume that your client has capacity. And that can be a challenge sometimes when there is elder abuse that has also happened. It's a challenge sometimes when somebody has been traumatized, because one thing we do know about the older adult population is that there can be medical conditions like the UTIs or other kinds of dehydration, and symptoms of trauma that can cause an older adult to appear not to engage, or to appear confused, or to not be able to answer directed questions, especially from an attorney who tends to be very direct. So I think it's really important for practitioners to make sure we're starting at the point of assuming capacity, and assuming that even with capacity, there may be reason to go slowly, there may be reason to pick a time of day that works better. We're fortunate at the Weinberg Center because of the shelter infrastructure. Our clients, are on the other side of my wall. So we get the benefit of practically living with our clients and therefore getting to know them in a very intimate way and being able to identify what their history is, what works for them, and who they really are. And to the extent certainly practitioners in the field do not necessarily have what I consider the privilege of getting to live with my clients, they having a relationship and history to go back to and to go forward with, I think can be very, very helpful in keeping this in mind. And don't presume anything. Families with elder abuse cases, they're among the craziest fact patterns out there. And it may not seem to make sense initially, but that doesn't mean that the older adult isn't credible. It could very well mean that the abuse is that sophisticated, complicated, or outlandish.
Sure. So what types of suggestions then do you have for practitioners that are engaged in advanced directive planning then in general for clients?
Knowing that there are these particular areas that can be very sensitive for an older adult, the point is you want to engage and you want to understand what their wishes are. In order to do that in order to do that successfully, I believe you need to do that in a trauma-informed way, especially when you know that there's been some form of elder abuse or harm that has already happened to them. Knowing a little bit of their history is really important to understand what it is how you can best serve them given their specific circumstances. Basic steps, being careful of the tone you're taking, going slowly, maybe doing one document at a time, offering breaks, being willing to connect on an emotional level. I would argue that time is maybe the most valuable offer that you can make for a client who you believe has experienced elder abuse, and being willing to really sit down with them and listen.
You've offered some really great tips and practices. Does this type of advice only apply to practitioners working with elder abuse victims?
In my opinion, no. I mean, my pathway to really learning about this came from working in the field of elder justice and working with clients who have experienced harm. But really, all of these subject matters that advanced directives touch upon it can be extraordinarily sensitive, and you have to look at the individual, their culture. I mean, I'm in New York City, so we have these amazing different cultures and languages, but with it, there needs to be an understanding of what death means, for instance, to various communities. There needs to be an understanding that values may shift, may change, and really could depend on the client whom you're trying to ascertain what those values are to best represent them and represent their interests. So, no, I think frankly, the statistics around trauma indicate that there is mass trauma that has occurred when we know, and really, it's our belief that all of these advanced directives should be approached in a trauma-informed way.
Nina and Deirdre, you both have shared great information about both an instrument for healthcare decision-making, the uniform law, and a process for healthcare decision-making, the trauma-informed approach to planning. Is there any intersection between what's available in the Uniform Act and the need to use a trauma-informed approach to advanced planning?
I guess I can take that one first. So I guess what I'd say is that the Uniform Act is designed to, in part, support the type of trauma-informed planning that Deirdre spoke about. One way it does that is through the optional form that it provides for people to use. It's a form they can use to name an agent and also to state their preferences for care. And that form is designed to work for people who have a very broad range of concerns, values, fears. It allows the person to just appoint an agent if that's what they're comfortable with, to just state preferences if that's what they're comfortable with, to just state values if that's what their preferences, or to potentially, do all three. And in terms of stating preferences, it provides the option to do that in an open-ended way, or to make things a bit more accessible, it provides a variety of options that people can select among. And a key thing there is it provides the options in a way that is designed to be value neutral, that doesn't push or pull people to select or reject particular options. And it also includes a section that allows people to share their values that they want to animate care decisions. So, for example, people have the option to explain, how important is minimizing pain, or how important is it to maximize longevity, or to involve family in decision-making processes. And we also know that people differ in sort of how they want those instructions to be construed. Some people are very clear. They want their agent to follow their instructions as written. Thank you very much, no deviation. But other people want their agent to have some flexibility and to make the decision that feels context appropriate at the time. And so the form has an option there for people to select which is the best fit for them. And perhaps what I like best about all of this is that in writing that form, we worked in close collaboration with a plain language expert, because none of this works if people don't understand it, if it's not accessible.
Are there other tools besides the Uniform Act that would help practitioners and clients engage in a meaningful planning process?
There are a couple ideas that we explore a little bit. An ethical will is something that we talk about and actually ask our clients if they're interested in completing, as a way to really highlight what they feel their value is and how they'd like to see that passed on. Whether or not there's anyone to pass it on to, it allows them the opportunity to be seen and heard and supported through the idea that they in fact have value, and that there are people out there who wish to honor those values, and that we are here to support them to navigate that path. Because so many of the people that since isolation, as I said, is such a hallmark of elder abuse, so often the people who we're seeing simply don't have anyone to appoint. And one of the ways we try to address or soften how that must feel for someone to acknowledge to themselves that I don't currently have a person to make these decisions for me if I can't, is to say, okay, but we can help you to articulate what's important to you. And we can help facilitate making sure that the doctors, have things like, in our instance, a MOLST is something that is used in skilled nursing facilities in New York State that is required to be filled out, and it's a doctor's order. And you're required to check in on it every year and update what the direction of that is. And while I believe there's some debate around the use of the MOLST, we have found that it's a really great tool that requires regular check-ins, that says because of where they are in their health and possibly their aging process, that we're listening. It's not a person they're appointing, it's what their wishes are. And we try to assure that that information will get carried out to the people who then are in the medical field ultimately making those decisions. We've tried also in guardianship proceedings when we have found that, okay, a person may need a guardian because they have functional limitations and will be at risk if there's no one there to help them, that doesn't necessarily mean that they can't articulate someone they would like to appoint, or that they have a particular desire about what they'd like to have happen at end of life, or where they'd like the remains to go, all of those kinds of things. So we focus on a lot of other tools to help bring confidence, empowerment, and autonomy to the older adult wherever they are.
And for us non-New Yorkers, what does MOLST stand for, Deirdre?
A medical order for life-sustaining treatment.
Thanks. Nina, do you have other suggestions for tools to use?
Sure. I think it's important to acknowledge that there's a lot of advice out there. And there are many organizations who are focused on particular diagnoses or types of care that offer specific guidance for people dealing with those particular issues. I also want to point out that the ABA Commission on Law and Aging has some really good resources on its webpage for lawyers as well as lay people. And I'll just share one tip that isn't necessarily on any of those. But one thing I sometimes hear is that people delay making an advance directive because they're struggling with whom to appoint, right? They're worried that if they appoint their son, their daughter is going to feel put out. And so that's understandable. But it's really important that people do this work to make it easier, not only for themselves, but for their family. So here's my little tip to get around this issue. I encourage people when they're thinking of who to appoint as their agent to not simply do it based on who they trust, but to do it based on who shares their values. Because one thing we know about surrogate decision makers is, as much as we might want to tell them what we want for ourselves, at the end of the day, you know what they do? They typically follow the golden rule. They do for you what they would want for themselves. So in trying to figure out who is your best surrogate, it's often good to ask them what they would want for themselves. And the great thing about that is not only do you get potentially a better surrogate, but then you're not choosing based on some sort of decision about which potential surrogate is more moral or more trustworthy. You can say to daughter, it's not that you're not trustworthy, it's just that your brother is a little bit nutty like me. And I think that has the potential to get people out of the bind, which so often results in them delaying in doing this important planning.
Well, thank you. You've both shared tremendously helpful information and practical tips. We are so grateful to Deirdre and Nina for joining us today. If you are interested in further information on this and other topics, check out our podcast notes on our website. You can also listen to this and other episodes by visiting the ABA Commission on Law and Aging's YouTube channel. Remember to like and subscribe to be sure to get any updates. We'll look forward to having you join us for our next episode. In the meantime, keep on advocating for the legal rights of all.